And this is our second episode of a special edition of what's going on here on LaGuardia Web Radio WLGR. I'm your host, Hugo Fernandez. The show is called May It Please the Court. And my two guests today are two professors in the Humanities philosophy program, or should I say Humanities Department's philosophy program. Doctors Vera Albrecht and Dr. Shannon Proctor. Say hi. They're waving to say hi.
Hi. Hi, everybody.
So folks who have not seen, didn't see the first episode, don't know what's about to happen. I've put together a PowerPoint that's been driving my staff crazy today, trying to figure out how to play. We're going to be playing the oral arguments of a particular case that comes from, actually, this is the book it comes from here, May It Please the Court. You can see that. And this one focuses exclusively on arguments on abortion. But this case precedes the most famous case, which we did last time, Roe v. Wade. It's called Griswold versus the state of Connecticut. And it deals with the issue of the distribution of condoms by Planned Parenthood. And it would be a foundational case. So what we're going to do is we're going to be listening to the oral arguments as recorded in the Warren court at the time. Earl Warren was the Supreme Court justice who was running it at the time. I'm at a loss. He wasn't associate. He was Chief Justice of the Supreme Court at the time. And those of you who've forgotten who Earl Warren is, he's the one who oversaw the Kennedy assassination investigation as well. So we're going to listen to the oral arguments while my team, Dr. Jamie Riccio and our engineer Chris Pope, are going to be playing a PowerPoint so we can see who's saying what. All right, so without further ado, let's turn it over for the oral arguments. But have you got that, Mr. Pope? He's on it.
Arguments on Abortion presents the case of Griswold versus Connecticut. The edited arguments are narrated by Professor Sylvia Law of New York University Law School.
Number 496, Estelle T. Griswold et al., Appellants versus Connecticut.
It's Monday, March 29th, 1965. Chief Justice Earl Warren has called for argument a case that began at a birth control clinic in New Haven, Connecticut. Estelle T. Griswold, director of the Planned Parenthood Center, and Dr. Lee Buxton, a Yale Medical School professor and the center's medical director, obtaining birth control devices. After a short trial, the judge found Ms. Griswold and Dr. Buxton guilty as accessories for providing condoms to a married woman and fined each $100. This was actually a test case, and their arrest was arranged with the district attorney. Both sides wanted a Supreme Court test of the state law, which was passed in 1879 and reflected Puritan and Victorian attitudes towards sex. Lawmakers felt that the biblical command to be fruitful and multiplied barred any interference with conception. In recent years, the influence of the Catholic Church in Connecticut blocked efforts to repeal the ban on birth control. This is not the first time that the Supreme Court considered the Connecticut law. 4 years before today's argument, in 1961, the justices dismissed a challenge to the same law, also brought by Dr. Buxton. In that case, called Poe versus Ullman, the court refused by one vote to rule on the constitutional issues because Dr. Buxton had not been arrested or threatened with prosecution. The Constitution does not allow the court to issue advisory opinions in cases that do not involve a real punishment. This time, the justices are ready to face the issue of birth control. Dr. Buxton has been convicted and fined. But more has changed in the past 4 years than the facts of this case. The publication in 1963 of Betty Friedan's book, The Feminist Mystique, raised the consciousness of many women. Control over reproduction and access to birth control are basic goals of the growing women's movement. Both sides have narrowed the case of Griswold versus Connecticut to this basic question. Does the Constitution give married couples the right to use birth control devices to prevent conception? The argument in favor of this proposition will be presented by Thomas Emerson, a Yale Law School professor who's a friend and a colleague of Dr. Buxton. He begins with the facts of the case. Chief Justice Warren welcomes Professor Emerson to the podium.
Mr. Emerson.
Chief Justice, may it please the Court. The evidence showed that Dr. Buxton had not only been medical director of the center and had made the medical decisions in setting it up, but he also had functioned as a physician during the operation of the center on several occasions and had examined patients and given them contraceptive advice. The evidence showed that Mrs. Griswold had taken case histories, had discussed methods of contraception with married women who came to the center, and on one occasion had given contraceptive materials to one of the women. There was testimony of 3 married women who had come to the center, had gone through the procedure which I have described, and were given contraceptive materials and thereafter used them. The center functioned in a suite of 8 rooms in a building in New Haven. It had a staff of doctors and nurses as well as Mrs. Griswold. The procedure was that when a married woman came to the center, she was interviewed, her case history was taken, and the various forms of contraception were explained to her.
Justice Hugo Black asked a factual question that began a lengthy discussion of constitutional issues.
Professor Emerson, how was the determination made that she was a married woman?
I do not know, Your Honor, except that in asking questions and taking the case history, I assume that it was accepted if she said she was married. But I'm not sure what the arrangements for that was. There's no question in the case but that the center functioned only for the purpose of helping married women.
Does the law allow that distinction? Discrimination?
The law makes no distinction between married and unmarried women, but our objection to it essentially goes only to its application to married women.
Well, why wouldn't it be a denial of equal protection of the law to draw such a distinction? Women need that. Well,
it might be, and I will argue that it does operate discriminatorily, Your Honor. The equal protection question as such was not raised in this case. And there might be differences between married and unmarried women for purposes of legislation in this area.
There's no authorization for the prescription of contraceptives to prevent disease or that sort of thing?
No. The statute applies without exception to prevent the use of contraceptives for purposes of preventing conception. The statute does not apply to the use or sale of contraceptives for purposes of preventing disease.
Well, is that the way that contraceptives are freely sold then?
That's correct, Your Honor. They are sold in Connecticut for purposes of preventing disease.
And yet you're making no equal protection argument at all.
We are not arguing equal protection clause of the 14th Amendment as such in this case. No, it was not raised in that way. We do say that the statute does operate discriminatorily and as part of our due process argument.
Justice Black was willing to consider an argument based on the Equal Protection Clause of the 14th Amendment, but he questioned Emerson's reliance on the Due Process Clause of the same amendment.
I can understand an argument from my own constitutional ideas based on equal protection. It seems to me what someone has done here deliberately to try to force a decision on the broadest possible grounds of the meaning of due process, speaking as a matter of substance, and to have us weigh facts and circumstances as to the advisability of a law like this rather than leave it up to the legislature.
Well,
as I understand it, however, you're abandoning your idea to any argument on equal protection. As such.
We have never made any argument on equal protection as such.
You pitch it wholly on due process with the broad idea that we can look to see how reasonable or unreasonable the decision of the people of Connecticut has been in connection with this statute.
We pitch it on due process in the basic sense, yes, that it is arbitrary and unreasonable, and in the special sense that it constitutes a deprivation of right against invasion of privacy. The privacy argument is a substantially narrower one than the general argument.
That's the due process argument.
That's correct.
Emerson argued that the Due Process Clause protected a right of privacy in matters of procreation. Justice Black, who stuck to the constitutional text, had doubts about this claim.
You expect us to determine whether it's sufficiently shocking to our sense of what ought to be the law. Because this applies to married people only.
Yes, Your Honor, but it is not broad due process in the sense in which the issue was raised in the 1930s. In the first place, this is not a regulation that deals with economic or commercial matters. It is a regulation that touches upon individual rights, the right to protect life and health, the right of advancing scientific knowledge, the right to have children voluntarily.
Emerson attacked the motivation behind the Connecticut law.
It's a moral principle. It's a religious principle that's being enacted into law, that it is immoral to use contraceptives even within the marriage relation, and therefore can be made an offense. That is the aspect of the statute we're dealing with at this purpose. And I say that is purely a moral judgment which cannot be measured by objective circumstances. There is nothing harmful about contraceptive devices, either to the individual or to other individuals. When we say that the state cannot enact such an abstract moral principle,
Emerson faced a final question about the Connecticut law against abortion and its relation to birth control.
That case is different from this situation because in the abortion cases, Connecticut does not apply this moral principle. It is the use of an instrument to prevent birth taking place. But they do not apply the moral principle that it can never be done. In Connecticut, abortion is allowed where it is necessary to save the life of the mother or the child. So that the basic moral principle that Connecticut is trying to enforce here, they simply pay no attention to in their abortion laws. It's a completely inconsistent application of the principle. They don't take it seriously in abortion cases, only in contraceptive cases.
Joseph Clark, a state prosecutor, defended the Connecticut law against birth control. He argued that it fit within the police powers doctrine, which allows the protection of public health, safety, welfare, and morals. Clark faced a barrage of questions from Justice Potter Stewart.
So what is the purpose of this legislation in Connecticut? Your basic argument in your brief and so far in your oral argument is that this is well within the so-called police power of the state of Connecticut. And what is its purpose?
Well, if Your Honor, please, I think its purpose is
to increase the population of Connecticut, or to impair its decrease, or is it what?
If Your Honor, please, I do not hold that it is to increase the population of Connecticut. I don't think that this is we could make this claim valid.
Well, what is it? What is the purpose?
I think it's to reduce the chances of immorality, if Your Honor, please, and I use the words immorality here in a broad sense. That is, in one way, to act as a deterrent to sexual intercourse outside of the marital relationship.
Well, the trouble with that argument is that on this record, this involves only married women.
That is correct, Your Honor.
So how can you make that argument?
Well, if Your Honor, please, I think that on this record, that the statute is a valid exercise of police power.
Well, for what purpose?
And if Your Honor, please, on this record, that there is a distinction, and there has to be a distinction between birth control and the use of contraceptives. That is to say that all contraceptives involve birth control. But in order to practice so-called birth control, one does not have to use contraceptives. And that the state is able to take this position and take this distinction, that there are, if it be said, well, should married people be allowed to use these devices?
Yeah.
Is not the state going too far? I think the state can answer to that there are other methods available to married people.
Well, now, for what purpose under its police power? Assuming we're dealing now with married couples.
It would not be improper for the legislature to consider that Connecticut, as any state, has a right to look out for its own continuation. This is the population argument. I personally am not too happy with it, but...
Well, what argument are you happy with?
I think, if Your Honor, please, the only argument that we can honestly say is that this is a question of pure power.
Well, do you suppose the state of Connecticut could prevent marriage?
I think the state of Connecticut could prevent marriage on certain people, certain groups, yes, if Your Honor, please. Between idiots, say, or age in marriage, I think, Your Honor, please, that...
But surely you'll agree with me they couldn't... I should think that you'd agree with me that the state of Connecticut should say there'll be no marriages contracted in this state. Be no sexual intercourse of any kind, married or unmarried.
I agree with you.
Well, now, what is the police power purpose of Connecticut in telling married people, two people who are married to each other, that they cannot use contraceptives?
Well, I think, if Your Honor, please, it's to preserve...
what kind of morality? What moral purpose is
Well,
that?
if Your Honor, please, it is not unheard of that the use of contraceptives themselves would be immoral. Certainly, this is a view that has been prevalent in history right up to the last few years in most groups. In Connecticut, I'm citing the brief of our opponents in one instance of the number of Catholics and Orthodox Jews in the state. If you were just to put it on a numerical basis,
well, you'd have quite a different case if the state of Connecticut compelled their all married couples to use them. That's not. That's when you'd run into the argument you're now making, that this violates the religious precepts and beliefs of certain groups.
This is true, but if Your Honor, please, it also would be more difficult for the state to control the result of what you might call dissolute action, that is, fornication and adultery.
Justice Arthur Goldberg took over from Justice Stewart.
If this is the evil that your state is trying to combat, you have other laws to deal with that, adultery laws, for example. Is that correct?
This is correct, if Your Honor, please, but the problem is that if contraceptives, say, are freely sold, dispensed, or otherwise used, even to married people, how can the enforcement, how can it be known that they will be used within the marital relationship? Not all people are immune from adultery. The problem would be greater. The problem of identification, the problem of conviction would be greater without it. I don't hold that I don't hold that the statute is the most wise way of putting this issue.
Professor Emerson had argued that the Liberty Clause of the 14th Amendment protected the right to use birth control. Clark disputed this claim.
Their rights to liberty and property in violation of the 14th Amendment was their ground under more on the ground they argued through. As I said, if Your Honor, please, it seems to me that this case is purely a case of legislative power, reduced to its narrowest sense. Does the legislature have the power to enact laws in this area? And I think the answer has to be said that it does. And then the question comes up, did Connecticut go too far? And this is it's said that this is a dead letter, this statute, but it is not. Every 2 years, the General Assembly meets in Hartford, and people troop up, and this is one of the most hotly debated issues before the Connecticut Assembly.
The final questions to Clark raised the basic constitutional issues in the case.
Well, do you say the constitutional issue is here to be decided in this court or not?
But, Your Honor, please, I say that they have not standing to raise the issues aside from freedom of speech and aside from claims of liberty and property.
Now, what you're saying would be relevant and perhaps with some persuasiveness if what Connecticut had done would be to compel everybody to use contraceptives. Then you could show that there's divided opinion about their value for certain people with certain physical conditions. But we have the other side of the coin here, and if the medical and sociological and religious views on this subject are divided, and it adds up on net balance to be relatively neutral, then what we have here is the freedom of people, of married couples, to do this if they want to. And therefore, I don't quite see the relevance of what you're telling us now when you remember what this case is about.
Well, if Your Honor, please, I can only say that married couples do not have freedom to do what they want. This has been the Connecticut decision, and this is the Connecticut holding. What we're saying is that the state can argue that people cannot go outside their own homes and get things and use them in their homes.
The Supreme Court decided the Griswold case on June 7, 1965. 7 justices voted to strike down the Connecticut law against birth control. Justice William O. Douglas wrote for the majority. He focused on the state's intrusion into the intimate relation of husband and wife and their physician's role in one aspect of that relation. Douglas based his opinion on the right of privacy, which he said was older than the Bill of Rights. Although the right is not specifically listed in the Constitution, Douglas argued that it is implied by the specific rights protected by the First, Third, Fourth, Fifth, and Ninth Amendments. Douglas was a former Yale law professor, and his opinion used strange terms like penumbras and emanations. Behind the big words was a simple idea. The protections in the Bill of Rights, when added together, create a zone of privacy that limits the state power over birth control. Douglas put the issue in one question. Would we allow the police, he asked, to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? Even the 2 dissenting justices objected to the Connecticut law. Justice Hugo Black said it was offensive to him, but he read the Constitution literally and could not find the word privacy in it. Black warned that allowing judges to create new rights from the Constitution will be bad for the courts and worse for the country. Justice Potter Stewart wrote that the court had struck down an uncommonly silly law, but he agreed with Black that the ban on birth control did not violate the Constitution. The proper way to change the law, Stewart said, was for Connecticut voters to persuade their elected representatives to repeal it. That is the constitutional way to take this law off the books. Since the Griswold decision, debate over reproductive rights has shifted from birth control to abortion. In 1973, the right of privacy became the basis for the historic decision in Roe v. Wade, which protected the right to abortion. Conflict over contraception has not vanished, however. School programs to reduce teenage pregnancy have sparked political battles in many communities. Griswold was not the final answer to the question of contraception.
Arguments on Abortion is a production of the Earl Warren Bill of Rights Project of the University of California, San Diego.
I don't know what happened there. I always thought that we were behind the stream. So I don't know if I interrupted that last little bit there. But we're doing a station break here. It's 1:29. You're on LaGuardia Web Radio, WLGR. And I'm your host, Hugo Fernandez, of the show What's Going On. Today, Griswold versus the state of Connecticut in our second episode of May It Please the Court. So we're back. And doctors, who would like to go first and chime in on the oral arguments in Griswold versus Connecticut?
Should I get started? Okay, I'll get started. So
you're unmuted.
You can hear me?
Yeah, I was just saying that since you're unmuted, Dr. Proctor's muted.
All right. So just as you noted before, it's important to see that this decision was crucial for the Roe v. Wade decision also. So that preceded with the Roe v. Wade decision that we talked about last time. I mean, just as something to point out, sometimes these older cases startle you with some things that seem a little bit kind of old-fashioned. I mean, the morality of, sexuality is only really moral in the married situation. And if you start listening to the case at first, you might wonder, why did they restrict it to contraception used by married couples, or in particular given to women who are married? And it was even challenged by the court, saying, doesn't that make a kind of an unreasonable and arbitrary kind of violation of equal protection of the 14th Amendment? So the courts even kind of challenged, and at first you might wonder, why did they not expand it? And it later becomes clear. I mean, it was a nice way to kind of preempt the morality argument that comes later, that comes on part of Connecticut. So, I mean, I think that was smart, even though the whole thing seems probably to many of the listeners now, or to us also, really kind of an old-fashioned idea to restrict the right to use birth control to married women.
Well, my understanding is that this is coming back, that there has been talk about this.
Yeah.
Not just, I mean, the fact that I think that the Planned Parenthood chose this with married folks because no one could say, oh, well, you're giving it to people to have sex outside of marriage. But they're saying, like, look, I'm giving it to a married person.
Right.
So what's the problem? But my understanding is that folks are looking to, again, challenge the distribution of condoms in states. So I know it seems like an old fuddy-duddy recording from, the 1950s, but, past is prologue. Dr. Proctor, I see you wanted to jump in here.
Yes, ready to jump in. That was just one area I was going to push back a little bit in this conversation, is to say it doesn't, unfortunately, seem very old-fashioned to me at all. And while access to birth control is something that perhaps since the 1970s people have not worried about, there are certainly conversations that go on amongst more sort of morally conservative legal minds that do believe that the state has the right to enforce that vision of morality, right? I think you can even see that in some of the political activity that went on this past week. You can see that some of the backing for that is really about what kind of judges get in place, and that has a lot to do with a certain, maybe you might say, fundamentalist notion of morality. And I don't think that birth control would be off the conversation if those efforts were to kind of come through.
Yeah, I was kind of sad that it was Hugo Black that wrote the dissenting opinion, because he's an interesting character. He was from the South, but he changed his views certainly on race, and I think was involved with Brown versus the Board of Education. But he was this strict constructivist, constitutional, like believes like the way it's written. So yeah, one of the fascinating things to me was in the argument is that the right to privacy is not in the Constitution. You want to talk about that?
Yeah, I think that this is something, when I was first introduced to this case myself as an undergraduate, that was really what we focused on. Is we do in this country often believe, of course, we have a right to privacy, but if we're looking at our formal rights, not at all. And I think, what was it the narrator was talking about, right? The use of this penumbra, these strange words, emanations and penumbras. And it's like, they really had to do some almost legal gymnastics in order to find this right. So it is really interesting.
Dr. Albrecht?
Yeah, I agree with you. And I mean, it's especially when, it's words come into play that not everybody is immediately familiar with. I had to look up the word penumbra myself again because it's kind of a strange thing. And yes, the interesting thing is that most legal scholars have questioned it, but most people have accepted that there is this right to privacy. And of course, here in the dissenting view, it's correct. There is really no such constitutional right, even though it's kind of the thing written in between the lines, or that we can kind of extract it from something else. But ultimately, there is no such right. And if there is such a right, it's only inferred and not stated either in the Bill of Rights or in the amendment. So that's problematic, even though other cases, I mean, obviously also the abortion case, but also cases like Lawrence v. Texas have been based on this right. And I think generally it is an accepted thing that there is such a right, although, there really isn't any such written right. And that's important because it will come back again, I'm sure. This is not the last time we've heard of this issue.
Go ahead, Hugo, sorry.
No, I mean, you mentioned the Texas case, and I'd like you to hip the rest of us up about that, and also tell us what, by definition, in its usage, what they mean by penumbra here.
Okay, penumbra, I mean, if you think it's kind of in the wide range it's covered. I mean, if you look up the word, I can tell, I wrote it down just in case somebody would ask me, partially shaded outer region of the shadow cast by an opaque object. What? But it's kind of that he said, overall, it's kind of covered. If we kind of think something is included, or emanation, it's kind of, we infer this from some other amendments, but it's not really there. Lawrence v. Texas was a case that had to do with, laws of where two homosexuals were kind of surprised by police going into the wrong house by mistake and finding them having sex, violating a Texas law. And they won the case based on privacy, on the intrusion of privacy. And it was, in this case, accepted here that the court will find that, well, what people do in the privacy of their own bedroom, right? And this came up here, the same thing, what married people do in the privacy of their own bedroom is really not for the, it's an intrusion of privacy if there are laws that restrict this behavior. And of course, go ahead.
Dr. Proctor, I think are you muted?
Did I just actually mute myself? Of course, as I was trying to apologize for interrupting you there, Vera, sorry. This is the topic I'm actually teaching my philosophy of law course right now, this question of when should the law enforce morality, right? And where do privacy and social morality come into this tension, and where is the line? Because I certainly would not want to agree with the blanket, whatever people want to do in the privacy of their own bedrooms is okay. I would certainly think that we can identify harms to others of a variety of sorts, but exactly where that line could be drawn as to what should be in the realm of privacy and the law should avoid, and what should be in the realm of perhaps there are issues with public morality that come in. I mean, we're certainly in many states not allowed to use any kind of drugs in the privacy of our own home, right? So when is it that harm is involved? When is it that privacy should be the most important thing? And how in the world do we draw that line?
Yeah, there was one point where Clark, I think, the prosecutor from Connecticut said that people do not have the freedom to go out, and get things and then bring them into the house. And I was thinking to myself, why not? But I could see how now you're, when it comes to the case. Dr. Albrecht, you're muted.
Okay, yeah. So just to jump off what Dr. Proctor just said, and we do teach, I also teach this in my law class, the very basic question, how far can the law go? I mean, where do we draw the line that the law can interfere with our liberties? I mean, that's the idea, the John Stuart Mill idea on liberty. So how far can the law go? And I mean, of course, it's not just a privacy thing, but it's, of course, we can go to the harm principle. Of course, we cannot take things into our bedroom like our rich Uncle Charlie and murder him there, just to make a joke. But, and of course, there would be certain drugs, and that's what in the Griswold case, they were referring to certain drugs or other things. But of course, that's a question not of so much harm of others, but self-harm, if we include drugs there. But so this is a wider range, but the general question would be, should we give the law the right to enforce morality? And that's a very fundamental question.
And how do you do that in a pluralist society such as our own, when there are competing and overlapping senses of good and evil? And so it's not as if it's unclear what shared moral principles do we really have in the United States that we could enforce.
Absolutely. And also, I thought in the Griswold case, the case was made that in Connecticut there was a population of Catholics and Jews who would, and it's kind of the state tries to enforce their morality. And the judge made the point, which I thought was very interesting. It would be a very different case if people were forced to use contraception, right? So you still have the right to not use it. So if you don't like it, if it goes against your morality, your religion, you can just not use it. So it's not that it is forced upon people. And of course, what you just said is, how do we come to a consensus of what is really moral? So maybe we should draw the line on how far the law can go elsewhere and not on moral grounds. But, then the question is, where is that line?
Yeah, I think you and I have had this argument before, Dr. Albrecht, about morality. And I've always taken the position that as an artist, I don't have any, short of the fact that, if I'm in a position to save somebody's life, I feel obliged to do so. But then, of course, there's the issue of ethics, and obviously, let's just say, at least for the purposes of my job at LaGuardia, I follow all those ethical rules. Anyhow, but what's fascinating about it is how this case is, they were trying to argue it at one point, and in fact, the Clark, the prosecutor, said, like, I don't, the issue around population, Porter Stewart, I think, he kept trying to say, like, exactly why did Connecticut create this law in the first, what is this about? Is it about, they have a population problem, or what it was? So at one point, but then the next piece, like you've both said, it goes into this issue of privacy. But obviously, as it moves later, 10 years later, let's say, and now we're at Roe v. Wade. Now it's about, folks determining whether or not, they are gonna procreate, in a sense, or, all these other kinds of issues. But I won't digress. By the way, we're at the last quarter hour. So I don't know if either one of you teaching right now and have asked students to tune in and ask questions?
I am, but I forgot. I'm a terrible professor. I forgot to send them out the link today.
Well, the beauty part is that we are recording this, even with all our.
So I can send them
By the way, I just want to say that the PowerPoint was much better today, as far as connecting it. I've been told I made a few mistakes, which the team had to correct. But we're going to get this right, gang. Eventually we're gonna make do this. Which, by the way, if you go on the internet, it turns out a lot of these cases have been on shows like C-SPAN 9, whatever like the the channels are, and so that you can watch video that do a lot of the same things that we're doing, where they put an image on there so you know who's talking. But anyhow, so we would take questions, but I don't see any coming up. Dr. Riccio, I don't know if she's going to shill us a few. So no questions in the chat, she's telling me. But I've learned how to now watch the Twitch and see where people put in stuff. So what other points would you like to make about this, since we moving forward? I mean, have you heard? We have talked about this issue that folks are trying to bring back, not allowing people to distribute contraceptives, and I think people don't realize, like, Margaret Sanger was arrested for distributing condoms, right? The woman who started Planned Parenthood. I don't know if you both know this. Professor Rodriguez lives on Margaret Sanger Place in right by the Planned Parenthood in
I don't even know his address.
Nolita. It is a very short street, but there are certainly a lot of doorways. So you pretty much have to stalk him. But anyhow, so yeah, what thoughts about this case beyond what we talked about?
I just want to make one little additional remark that's not exactly related to the case, but related to the fact that it was the distribution of condoms.
Right.
Way later, when AIDS became a real problem.
Right.
That the distribution of condoms was really also a measure of preventing the spread of a disease that, especially back then in the 80s, they didn't really have a grip on that. Now it's different because you can survive it. But back then it was kind of also a way to prevent the spread of disease. And there was not, I mean, of course, there was the morality argument is a whole different one in that case, because the disease largely spread by homosexuals.
Well, that was the initial population where it showed up at the time. It was even called the gay cancer. Mm-hmm. And there were a lot of people, I mean, it took the federal government years to actually even acknowledge its existence. I know, I can't remember what year it was Reagan finally said the word, like 85 or something, maybe even later. I think Shannon's saying it even later. But yeah, it would be interesting because now, I mean, we have COVID. So if people were saying, well, you have to wear condoms to prevent getting COVID, would they be, who's going to distribute those then?
And especially as people have even problems wearing a mask. So.
Yeah, that's right. So then they're.
But
one thing, Vera, I was going to just go back to this point you're saying about the spread of disease. That was actually, they talked about this in the case, right? That even in Connecticut, you were allowed to sell condoms if it was for the prevention of disease, or you were allowed to sell any sort of form of birth control. Yeah. So I think that also, again, highlights that this case was less brought out of a strict necessity, because certainly the doctors could have articulated some reason why these married couples needed condoms to prevent some sort of disease. But I think it was more out of this desire to move the social kind of conversation and understanding of sexual morals forward.
Mm-hmm.
Well, what's interesting is that they talked about how the whole case was kind of set up between the Planned Parenthood that was actually running out of Yale medical program, and they talked to the district attorneys, whatever, to make, because they'd had a previous case that wasn't quite right. Okay. So now they had this case. And but interesting, at the end, when Justice Porter Stewart was saying that basically he felt, it was a stupid law, but that it had to be legislated out of existence for it to be constitutionally appropriate. And I find that fascinating that here's a Supreme Court justice that's telling you the only way to do something constitutionally is to do it through the ballot box or whatever, do it through, your executive branch, rather than, I mean, again, Hugo Black saying that, they were going to make, they talk about this all the time. It's like you can win a case and make bad case law, right? Mm-hmm. And that's, I think, what Black was referring to, is that now here I am trying to talk about privacy, which doesn't exist in the Constitution as a right. And I'm trying to and so that's why he was against it. He didn't like the law either, right? He thought it was insulting. Mm-hmm. So, but I think I was just thinking to myself, like, I don't know, given the political climate we have today, even if you could get an amendment through the House and the Senate, to get it approved by a third of the 2/3 of the states, that I forget what the number that have to basically approve an amendment before it's legally binding. I don't know if it ever happened. It's certainly not around these issues, right, of sexuality, or I don't know.
Also, that's making me think of how difficult it could be. Like, even if you think you just had to get out state legislatures in Connecticut, right? Elect new state representatives. If you're in the minority if you're in the sort of moral minority of a state, then the suggestion here is that there's going to be very little recourse for you if we don't have this right to privacy, right? That you're going to kind of be forced to follow along with the majority here.
Well, I think I don't know if you've ever seen the film The Life and Times of Harvey Milk. And Harvey Milk talked about what it would be like to be born gay, or realize you're gay, and like, what were your options? Stay in the closet, or you come out and you be persecuted in your community. And he was saying, like, now you have another option, which is you can move to San Francisco, and which many people did, or New York. But yeah, you're right. It's this idea that if, the notion of the Constitution is it's supposed to protect the folks that are the most susceptible, that are most susceptible to the majority to be harmed. But it doesn't seem to be that's the way it's being played out, at least not, that's the way things are going.
Just want to add one thing, which I thought was a pretty kind of a weak argument at the end by Clark, who said, well, of course, even if we don't, and he was questioned as to whether there is really a problem of morality if married couples use contraception. And the whole problem was that of fornication and adultery. And his argument was that, of course, if the contraceptive devices are available, we don't really know if people who are not married are getting access to it. So you're in a way regulating something in case somebody, and this is where you could see, at first you may wonder, why is it that that Emerson did restrict it to married couples? The case was made restricted to married couples. And I think that was a smart move in this case to preempt just this whole morality argument in the end. And just to say, well, you know what, we don't want to make it legal because it could be used by people who shouldn't be using it. That's kind of, if you go by this, then, we shouldn't be selling alcohol because it could be used by minors.
Like devil's advocate, there was some of that reasoning when they talked about opiates, prescription opiates. There has been some push of like, how might overprescribing, which maybe itself we could talk about in another show, lead to people who didn't have the prescription getting it. And they did make it harder to get those prescriptions, in part because of that. I don't know if that's great reasoning, but it happens.
Well, it is the reasoning. My daughter just is now legal. But anyhow, you can imagine. She has a boyfriend who lives in Massachusetts. They have different laws than Connecticut, where I live now. Interestingly enough, I live in the state of Connecticut. So it's always going to be this issue, and which is why policing doesn't really work anyway, and for the most part, certainly in these kinds of situations. But we're moving to the end of the hour here. So any last words on this particular case before we close? You're good? Well,
I mean, Vera and I could talk forever about anything, but no, I think we got on the central thing. Thank you again, of course, for bringing us here to have this great debate.
And it is recorded, so you can play it back to your students.
And the last word for those interested in, we both teach the philosophy of law course. So right now there's Professor Proctor is teaching 2 sections of it. Next semester, it will still be offered. I will have 1 section that will be fully asynchronous, if you don't want to commit yourself to a specific time. But at the end of the semester, I don't know if you do this at the end of the semester. At the end of the semester, we deal with constitutional issues, such as this case.
Yeah, constitutional, and again, we should give our thanks to our NYU professor Sylvia Law. Great name for an attorney. That she was the narrator. We should reach out to her sometime and talk to her. So I was going to tell you, our next case, once we set a date, is Harris versus McRae, which is a case that never heard of it. Well, don't worry about it. I'm going to send you all the specifics, but it deals with Article 19 of the Social Security, or should I say Title 19 of Social Security law, which is basically, can abortions be federally funded? And we know where that's going. So, you're you're getting ready for that. So, if you've been watching, the show is What's Going On. I'm your host, Hugo Fernandez, and here on LaGuardia Web Radio, WLGR. And my guests today have been Dr. Vera Albrecht and Dr. Shannon Proctor, who are both philosophy professors who, if you're looking for a class, teach the philosophy of law, which is running in spring 2020. And we've been dealing with the case of Griswold versus the state of Connecticut, utilizing recordings of the oral arguments in the Supreme Court that have been collected in something called May It Please the Court. And this one came from a special segment called Arguments on Abortion specifically. By the way, apologize, we are transferring tape to digital, so there were some dropouts, not to mention all the mistakes I made. And I just want to thank my team behind the scenes, Dr. Jamie Riccio, station manager, who put together the video strip. I've asked her to get rid of the Ken Burns effect for next time. And also our engineer, Christopher Pope, who by now probably wants to strangle me. So and I just want to thank all of you who've watched and listened. Thanks. And take us out, Mr. Pope, the way we came in.
Thanks for having us.